I'm Shannon Lam. I'm a partner at Knobbe Martens, where I provide IP, portfolio, and diligence counsel to medtech companies and investors. Knobbe is proud to be a founding sponsor of LSI, and we're excited to support all the innovators and the investors that are here at this conference. Just to give everyone a little bit of background on Knobbe, we are a full-service IP law firm based here in the U.S. We have one of the largest medtech practices for IP as well. Year after year, we're one of the highest filers of patent applications in the med device space and have the largest number of granted patents in the medtech space. We also provide diligence counsel for both companies and investors, and we also have a robust medtech litigation practice. Just to give you a snapshot of some of the recent deals that we've been involved in, I think some of the bigger recent publicity ones have been LymphFlow and Relievant. I was personally honored to be a part of OpSens and AcuFocus and Novonate in all of their acquisitions. You might have also recently heard of our firm in the news representing Masimo and its litigation with Apple, where we're very excited to have obtained the first ITC injunction ban against Apple. So it's been very exciting news for us. I stand up here every year and don't want to spend 5 minutes talking about our firm. So I always like to just give some practice tips to some people in the audience based on recent cases. First of all, I know folks are always thinking about maybe what the patents are that are in the prior art, but I think folks often forget that there's other prior art out there, like public uses, and there's been recent cases on that about patents being invalidated from prototypes being showed at industry shows. So just keep in mind that even activities like that can keep you from getting patents, and also even just disclosing things in presentations like this at LSI or any other sort of technical paper. All of those things could be used to invalidate patents. So it's always really good to just be in contact with your patent attorney about what's going on with the business. The other interesting, just recent patent case that's come up is between Pfizer and Moderna, and that's regarding statements made at the FDA compared to statements made at the patent office. You can imagine companies are often at the patent office touting how novel and not obvious and inventive that their inventions are, but then they often go to the FDA and they try and rely on prior products, whether it's to get the 510K approval or, in the pharmaceutical industry, trying to rely on prior clinical studies. And you say, oh, well, we're similar enough to what's going on in these other products. And you can imagine that there's an inconsistency there between the two statements, and the patent office is starting to investigate that a little bit more. So again, it's important to just keep your patent counsel informed about, what other predicate devices or other clinical studies that you might be relying on at the FDA.